It was a very important decision issued by the Supreme Court there last week. It's to do with the Domino's pizza delivery drivers. And the question arose and has run. The issue has been fought over for actually 13 years. And this case originally was decided by the Revenue Commissioners that the drivers, the Domino's pizza drivers in the Midlands were employees. The Revenue Tax Appeals Commission also agreed that they were employees. The High Court agreed that they were employees, and then it was appealed to the Court of Appeal, and the Court of Appeal overturned the previous decisions and decided that they were actually independent contractors. And then the case was appealed again to the Supreme Court, and the Supreme Court now have decided that the Domino's pizza drivers are employees. I published a video about this last week on TikTok and Facebook and YouTube, on my YouTube channel, and lots of people were asking the question, people who might be involved in the so-called gig economy, does this mean now that they're employees rather than independent contractors? Does this have significant precedent value for them if they're in similar jobs, perhaps not delivering food or delivering pizza, but maybe doing similar situation, similar work, or even different work, but in a similar relationship with the provider of the work, whether that's an employer or not? I want to just speak about that issue, that question, and the short answer is this is not applicable across the board in that way. It is applicable and very, very useful in deciding the issue if there's any dispute as to who's an independent contractor and who's an employee, but it doesn't necessarily follow that this case is going to be applied across the board and all persons involved in doing this type of work and who are in the so-called gig economy are now employees. It doesn't necessarily follow. It will depend very much on the terms and conditions of each particular situation. Now, if we look at the background to this case, and it's no harm to look at it, the case itself is the Revenue Commissioners versus Carshan Midlands Limited, trading as Domino's Pizza. The background is a demand by the Revenue Commissioners in 2014 from Carshan Midlands, trading as Domino's, a Revenue Commissioners demand of €215,718. This was based on the Revenue taking the view that the drivers were employees, not self-employed independent contractors. Carshan, then the employer Domino's, appealed this decision to the Revenue Appeals Commissioner, who agreed that the drivers were employees. The company then appealed to the High Court, who agreed with the Revenue Commissioners that the drivers were employees. Carshan then appealed to the Court of Appeal. The Court of Appeal overturned the High Court decision and held that the drivers were actually self-employed, not employees. The case was then appealed to the Supreme Court, and the Supreme Court have now decided that the drivers were employees. The significant part of this is, firstly, the Supreme Court has given 5 questions to look at in these types of dispute. So those 5 questions will have to be looked at and will give a good guide, good signpost as to whether a person, an individual worker, is an employee or an independent contractor. Those 5 questions are important. And the other significant feature of this Supreme Court decision that came out last week in October 2023 is to do with a concept called the mutuality of obligation. It has always been the situation in Irish law, employment law, that if there was no mutuality of obligation, then there was no employment contract. That means that if the employer was not obliged to give work, or if the employer did give work but the employee was not obliged to do the work, then there was no mutuality of obligation, and therefore there was no employment contract. Because let's face it, an employee can't say, yeah, you're giving me that work, thanks very much, but I'm not going to bother doing it. Because he wouldn't be an employee then, he'd be no longer an employee, he'd be an independent contractor, perhaps with other clients and so on. So the question of mutuality of obligation was vitally important and was seen as a sort of a threshold test. However, the Supreme Court in this decision, interestingly, have decided that the mutuality of obligation test that has been applied was actually applied erroneously by the High Court, the Court of Appeal and the Supreme Court in previous decisions. This Supreme Court decision says that the mutuality of obligation does not oblige the employer to provide work. It obliges the employer to pay for the work. And that means that a person could be doing work, and even though they may be coming and going in terms of doing the work, they could be actually an employee for a particular period of time, as opposed to being an employee all of the time. In other words, they could flit in and out of employment with a particular company or provider of work. And that's another important aspect of the mutuality of obligation, the necessary that it's a continuous obligation. That's not the case either, according to this Supreme Court decision. It's always been understood that the mutuality of obligation principle as set out in the Minister for Agriculture versus Barry was as follows. The requirement of mutuality of obligation is the requirement that there must be mutual obligations on the employer to provide work for the employee and on the employee to perform work for the employer. If there's no mutuality of obligation, it's not necessary to go further. Whatever the relationship is, it cannot amount to a contract of service. This mutuality of obligation principle or test has been held up to be the test. But the Supreme Court in this decision has now decided the test is not whether an employer is under an obligation to provide work. The obligation is to pay for the work, and that's a significant change. The Supreme Court has now decided that the obligation must be continuing and ongoing, or the idea that the obligation must be continuing and ongoing is erroneous, is mistaken. And again, this obligation to provide work was seen as a continuous and ongoing obligation on the employer, and if that was missing, if that wasn't there, then there was no contract of employment, no employer-employee relationship. The Supreme Court now is saying no, it doesn't have to be continuing and ongoing, and the worker can be an employee for certain periods of time. In other words, can flit in and out of an employment situation. It is possible for a worker to intermittently work for an employer and be considered an employee for those periods of work. So the Supreme Court has now held that the mutuality of obligation test is not a threshold test, even though it is relevant in arriving at a decision as to whether the worker is an employee or not. And when it comes then to looking at the question of a worker being an employee or a self-employed contractor, the Supreme Court has given 5 questions that must be looked at. The Supreme Court in this decision has referred to the previous Supreme Court decision in the seminal Henry Denny case, and it has set out 5 questions that need to be addressed to determine the issue in any given situation. 1. Does the contract involve the exchange of wage or other remuneration for work? 2. If so, is the agreement one pursuant to which the worker is agreeing to provide their own services and not those of a third party to the employer? So that's the element of personal service. 3. If so, does the employer exercise sufficient control over the putative employee to render the agreement one that is capable of being an employment agreement? 4. If these 3 requirements are met, the decision maker must then determine whether the terms of the contract between employer and worker, interpreted in the light of the admissible factual matrix and having regard to the working arrangements between the parties as disclosed by the evidence, are consistent with a contract of employment or with some other form of contract, having regard in particular to whether the arrangements point to the putative employee working for themselves or for the putative employer. Finally, it should be determined whether there is anything in particular or in the particular legislative regime under consideration that requires the court to adjust or supplement any of the foregoing questions. So these 5 questions need to be addressed, but the first 3 questions are tests which must be passed, or questions 4 and 5 do not arise. The decision also goes on to identify some factors which are incompatible with the contract of employment or a contract of service. The court says that the law makes it clear that the capacity to profit in a material way from their own skill, the need for the employee to invest significantly in their ability to undertake the work, and the requirement to bring tools or equipment to the task all lean against the existence of a contract of employment. The decision also flags up the question of control and states it's appropriate to consider control again at this stage, as there will be cases in which it is so extensive as to point overwhelmingly in the direction of employment, just as there will be cases in which it is so attenuated as to push the agreement towards another type of relationship. It is not possible to separate the question of control from the question of whether the evidence points to the worker carrying on the business on their own account. In the particular case then, the Domino's pizza delivery drivers, applying the 5 questions set out above, the Supreme Court agreed with the Revenue Commissioners and the Appeals Commissioner that these drivers were employees and not engaged in their own independent businesses. It is worth noting that the drivers were given contracts in which it was set out on 4 separate times in the contract that they were independent contractors. Thus, it's easy to see that regardless of what a written contract might state, it is only one factor to be considered in these types of cases and is not determinative of the status of the worker. So the court also warned against trying to apply this decision across the so-called gig economy, as each case must be decided on its own particular facts and circumstances. So that answers the question that I raised at the outset of this, as other workers have contacted me. Am I now an employee rather than an independent contractor as a consequence of this decision? And the answer is no. It will really depend on the circumstances of each particular case and the facts of each particular case, because they will vary from one place to another. Nevertheless, the principles set out in this decision, including the 5 questions to apply, are an extremely useful guide for anyone grappling with the question of employer or employee independent contractor in any situation. You can read the full decision of that Supreme Court case on my website, employmentrightsireland.com, and if you've watched this video on YouTube, then you might give it a thumbs up down below and consider subscribing. And you may have listened to this on my podcast, the Irish Law and Small Business Podcast, which you can access on Spotify or iTunes. If you do, I'd appreciate if you left a review for me. Thanks a lot.